Great. Well, thank you everybody for joining us this evening. My name is Randy Lepla. I'm the director of the Environmental Law Clinic here at the law school. We are in our first semester, and it's a brand new clinic, so I'm excited to be here with you guys, and I'm excited to have Professor Adler join us this evening as part of Climate Action Week. This is the second ever Climate Action Week here on campus, and then this is a university-wide endeavor. And so we're really excited to have you join us, and really grateful for the partnership with the law school joining as part of campus-wide Climate Action Week. So the event tonight is titled Climate Change Goes to Court, and we're really grateful for Professor Adler agreeing to join us for this. And so last spring, the Supreme Court curtailed the EPA's authority to reduce greenhouse gas emissions from the power sector in West Virginia versus EPA. Additional lawsuits have been filed by state attorneys general and conservative groups challenging a wide swath of the Biden administration's climate policy initiatives, including the use of the social cost of carbon. At the same time, state and local governments have filed suits against fossil fuel companies in state courts, seeking compensation for local climate change impacts and seeking to hold such companies responsible for the consequences of consuming their products. These cases have been consumed by procedural wrangling, but could also end up in the Supreme Court soon. So we're excited to have you all here for this discussion, and I will give a brief introduction of Professor Jonathan Adler, who is the inaugural Johann Verhey Memorial Professor of Law and founding director of the Coleman Burke Center for Environmental Law here at Case Western's Law School, where he teaches courses in environmental, administrative, and constitutional law. He's also the author or editor of 8 books, including the forthcoming Climate Liberalism, Perspectives on Liberty, Property, and Pollution. His articles have appeared in publications ranging from the Harvard Environmental Law Review and Yale Journal on Regulation to the Wall Street Journal and New York Times. He's testified before Congress a dozen times, and his work has been cited in the U.S. Supreme Court. A 2021 study identified Professor Adler as the 5th most cited legal academic in administrative environmental law from 2016 to 2020. And so we are really pleased to speak with him today about some of the forthcoming cases that will be at the Supreme Court and some of the things that have happened so far. So we can give Professor Adler a warm welcome. So we will just kick it off with a pretty general question here. There's been a dramatic increase in climate change litigation in U.S. courts. What explains the increase, and do you anticipate it to continue?
Sure. First, it's good to be here. The Burke Center is happy to be cooperating with the rest of the folks in the Climate Action Network on these series of programs. So there's been an increasing amount of climate change litigation in federal court going back to the 1990s, and it's driven, I think, by a handful of factors. One of the most important factors is the lack of meaningful action in Congress to deal with climate change. And so folks that are concerned about climate change look for other avenues of advancing climate change policy. And one of those is to file litigation seeking to drive policy. The most significant case that folks may have heard of in that regard is Massachusetts versus EPA, Supreme Court decision in 2006 that concluded that greenhouse gases are air pollutants subject to regulation under the Clean Air Act. That was certainly an important case that was filed in court, designed to make up for the fact that Congress had not then, and still today, had not enacted legislation designed to regulate or curtail greenhouse gas emissions, as opposed to most recently the IRA, which seeks to fund and support less emitting technologies and infrastructure. Another set of litigate suits that's been increasing have been efforts to use common law causes of action against emitters of greenhouse gases, and those have been increasing dramatically. Those have come in waves. So there was an early wave of those in the early aughts that were seeking to curtail emissions under various federal common law theories of interstate nuisance. The Supreme Court, in a case called American Electric Power versus Connecticut, said that federal common law suits are displaced, which is a fancy way of saying because Congress has enacted the Clean Air Act, federal common law no longer operates to control things that are subject to regulation by the Clean Air Act, and that, at least in their interstate character. Since the AEP, but the court said in the AEP, state common law causes of action, which are what most tort suits are, most nuisance suits are state law claims, they're not federal law claims. So there's been a new wave of litigation, which I know we'll talk about more in a little bit, of state law claims. In fact, there all throughout the country, and in almost every circuit there are cases raising state law claims. And then there are a lot of increasing number of administrative law cases involving climate change. Some of these are brought by folks that are concerned about climate change and want to see greenhouse gas emissions reduced. A lot of these cases are things like National Environmental Policy Act suits claiming that environmental impact statements have not adequately accounted for the impacts of greenhouse gas emissions and climate change impacts. Similar suits seeking to have greater consideration of greenhouse gas emissions and their effects under other federal statutes. And then we've also seen litigation filed by opponents of greenhouse gas litigation, what we often characterize, I guess, as red state lawsuits, since a lot of these suits have been filed by attorneys general from more conservative states, challenging initiatives by the Obama administration and the Biden administration to regulate greenhouse gases. So you add all these things together, and you see a very dramatic increase in cases that require federal courts to consider climate change impacts. And then that's setting aside purely state court cases, of which there's also been an increase. Some of those under state regulatory laws like state environmental policy acts, and some of those being common lawsuits.
Great. Well, the Supreme Court, and I think this is what the case most of us have heard of most recently, but the Supreme Court considered its fifth climate change case in this past term with West Virginia versus EPA. Can you give us a little bit of the background on that case?
Yeah, so this is a case that was a long time coming. It was a big case. It was decided on the last day of the term last year. It's a case that I would assume all of you, since you're here, have heard something about, West Virginia versus EPA. To understand the case, you kind of have to go back a little bit because it relates to things actually that occurred in the Obama administration. And it's kind of odd to think that, in 2022, the Supreme Court is still resolving cases about things that happened in the Obama administration, but that's the nature of litigation over regulatory policy. It can take a long time. It's not a very fast moving thing. So the Obama administration, after Massachusetts versus EPA, and after once the Obama administration came into office, began the process of applying the Clean Air Act to greenhouse gases. And one of the things the Obama administration did, one of the most ambitious things that it did, was adopt something called the Clean Power Plan, which was to use Section 111 of the Clean Air Act to control greenhouse gas emissions from the power sector, from fossil fuel-fired power plants, primarily focused on coal-fired power plants, which are a major source of greenhouse gas emissions in addition to other pollutants. And the Obama administration, the Section 111 of the Clean Air Act is a provision of the Clean Air Act that is source specific. It authorizes the EPA to adopt regulations for a given one category of emission sources at a time, and to then identify what the best system of emission reduction is from that category, and then require adopt standards initially for new facilities in that category, and then existing facilities in that category to meet a best system of emission reduction. In the case of power plants, if you think about the traditional things we do to control pollutants, you do things like you put scrubbers on stationary sources, or you improve their efficiency. If you're talking about power plants, a lot of what you're doing are things that improve efficiency, like heat rate improvements. And you don't get a lot of emission reductions that way. Heat rate improvements from coal-fired power plants will get you a couple percentage points of reductions over many years. The reason you get so much carbon dioxide emissions from those power plants is because they're burning coal. There's really not, barring dramatic advances in things like carbon sequestration or carbon capture and sequestration, you're not going to get much of it. So the Obama administration thought that the language of the Clean Air Act is broad enough to allow for treating greenhouse gas emissions differently than the way we treat traditional pollutants under Section 111. And so their view is, look, if we're talking about the power sector and you want to reduce emissions from the power sector, you wouldn't be trying to squeeze out additional marginal reductions from coal-fired power plants, you'd use coal-fired power plants less, and you'd replace that with gas, or you'd replace that with renewables, and you would require utilities either to substitute themselves to run the coal-fired power plants less compared to these other sources, or you'd have some sort of trading mechanism where they can acquire credits that would have the same effect of displacing coal use for other sources of generation. And these sorts of strategies are often referred to as generation shifting. So the Obama administration said, we're going to do generation shifting, and that would have the result, in their view, of dramatically reducing coal use. They thought that would reduce coal consumption by something like in the power sector by something like 25%, and would produce far more significant emission reductions from the power sector. That was controversial. The Clean Air Act this provision of the Clean Air Act hadn't been used that way before, so that combined with the fact that environmental policy is very polarized, that regulation is issued, Clean Power Plan is issued, it's immediately challenged in court, and in a somewhat unusual move after the DC Circuit refused to stay the regulation, the Supreme Court entered a stay. And what that means is, normally when a regulation is issued, there'll be deadlines. You have to meet certain compliance targets by certain dates, and so that the regulated industry knows, okay, here's what we have to do and when we have to do it. And a stay is basically a pause button. You can't begin to impose any of these requirements or enforce any of these deadlines. And so the Supreme Court stayed the Clean Power Plan. We believe it was the last vote that Justice Scalia took as a justice before he died. That was very unusual. That was in 2016. And it was basically a way of saying we're not going to allow the Clean Power Plan to get implemented until courts have had the opportunity to actually evaluate whether or not this somewhat innovative or aggressive interpretation of the Clean Air Act has been evaluated. As we all know, the administration changes. Trump administration comes in. President Trump issues an executive order, among other things, telling federal agencies to be more friendly to fossil fuels and to rescind policies that the Obama administration had adopted to reduce fossil fuel use, Clean Power Plan being one of them. And I know this is a long lead up to the case, but it's important to understand kind of what was at stake and what was going on. Trump administration eventually adopts a rule called the ACE rule, which is called the Affordable Clean Energy Rule. And in that rule, the Trump administration said, we read the Clean Air Act to only allow traditional, what people often say are inside the fence line measures to reduce pollutants under Section 111. The idea being is that traditionally, we think of this as a source-specific provision, and so the things that are part of the best system of emission reduction are things you do at the individual facility, as opposed to things you do system-wide throughout the grid. And the Trump administration said this is the only proper way, or this is the clear, unambiguous meaning of the statute. So for those of you that are familiar with Chevron, they're basically saying this is Chevron step one. This is the only thing the statute can mean. Therefore, the Clean Power Plan is illegal. And our alternative, the Affordable Clean Energy Rule, is the required regulation. And they said, but considering costs and other things, therefore the only thing that can be required are heat rate improvements, which, as I already explained, gets you like next to nothing. But it's important to understand that the Trump administration's new regulation was based on its interpretation of the Clean Air Act. That, of course, gets challenged, like everything else does, although it's blue states challenging it and environmental groups as opposed to red states. And that goes before the DC Circuit. The DC Circuit, the day before inauguration, which is unusual, invalidates the Trump rule, holding that its interpretation of the Clean Air Act was wrong and arbitrary and capricious. That meant that both the Trump administration's new regulation and its repeal of the Clean Power Plan were both invalid. Right, so we flip back to not that we wipe the slate clean and have nothing, but we flip back to the Obama rule. That didn't make a lot of sense because all of its deadlines had long passed, or not, a bunch of the deadlines had passed, And at least at a national level, there's some good news in the story, at a national level, the overall greenhouse gas emission reduction targets for power plants had been met. They hadn't been met in every state, and the Clean Power Plan required reductions on a state-by-state basis, but nationally, we'd actually reduced emissions more than the Obama administration had thought was likely. And so the EPA asks the DC Circuit to stay the ruling, again, push that pause button again, so it didn't have to try and enforce an old regulation that was now out of date. That decision of the DC Circuit, invalidating the Trump rule and invalidating the Trump rescission of the Clean Power Plan, is the judgment that was reviewed by the Supreme Court in West Virginia versus EPA. So what the court was asked to consider in that case was the DC Circuit's interpretation of the Clean Air Act that allows for the Clean Power Plan and did not allow the ACE rule to be the only possibility. Was that a correct interpretation of the Clean Air Act? And I think you're now going to ask me what the court did, right?
I think I am.
Okay.
And right, to Jonathan's point, this is really important background because it sets up this very long history, but this is how we got here, and this is why the court is now before, or was before, or the case was before the Supreme Court. So what did they decide, and why was that significant?
And I'll say one thing else, and this, I have a paper on this, so maybe it's one of my own hobby horses, but I think it also highlights why a lot of people in this space really put such an emphasis on Congress acting, because Congress can act quickly if it wants to. Congress can set deadlines, and Congress can eliminate opportunities for lots of administrative law litigation that delays the process. Whether or not one thinks the EPA has a lot of authority under the Clean Air Act, and folks differ on that, if the EPA is going to use Clean Air Act authority to do something like this, we know that everything it does is going to be litigated. That litigation is going to take a long time. The more the EPA is worried about litigation, the more time it's going to take the EPA to develop its rules. So the Clean Power Plan took several years for the Obama administration merely to develop. It took the Trump administration multiple years to repeal the Clean Power Plan and come up with an alternative. So it's a slow process. And that's just worth keeping in the back of your head. When people say, why, EPA has power, why do we care about what Congress does? Well, one reason is Congress can do things a lot more quickly, and all these kind of Administrative Procedure Act sorts of legal challenges don't apply against Congress because they're procedural restrictions on agencies. Okay, what did the court do? The court first said, first addressed questions about whether or not this was an appropriate case to hear. I'm going to set those issues aside, I think, initially, just for time purposes, but if people want to ask me about them, I'm happy to walk through the Article 3 standing sorts of questions. The court concluded more or less unanimously that it had traditional Article 3 jurisdiction. There was disagreement on the court on whether it was proper for the court to hear a case about a regulation that is from 2 administrations ago that the current administration doesn't want to enforce. And had the DC Circuit not issued its opinion, had the litigation still been going on, that would have happened, right? There would have been no decision. On the merits, the court concluded that the EPA does not have the authority under Section 111 to use generation shifting as the basis for the best system of emission reduction that existing power plants must meet. And I said it that way to kind of be very careful, because there's been a lot of reporting and tweeting and whatever about the case. That's not right. The court did not say the EPA cannot regulate greenhouse gases. It did not say the court cannot regulate greenhouse gases from existing power plants. It did not say that the EPA cannot regulate greenhouse gases from existing power plants under Section 111. It said it can't do those things in the way that the Obama administration wanted to do. Now, as a policy matter, that's important, because if your goal is to reduce greenhouse gas emissions from the utility sector, generation shifting is going to be the most efficient and effective way to do it, and it's why many utilities were actually on the EPA side in this case, because they said, hey, look, we're already doing this either because we think it makes sense economically or because we've because of political pressure in the jurisdictions we operate, or whatever the reason. And this is the way we do it, right? We don't try and retrofit all our facilities. We realize that on the grid, you can reduce the utilization of some power sources and increase it with others. And there are markets that enable you to do that. And it's an efficient way to ensure you're generating the amount of energy you need to generate, or amount of electricity you need to generate, and minimizing your greenhouse gas emissions in the process. So court said EPA can't do this. The reason the court said this, or the rationale, which is somewhat controversial, and I have a paper that's critical of the way the court did this, was to rely on something that's referred to as the major questions doctrine, and in a particularly aggressive way. The idea of the major questions doctrine is the idea that when Congress gives power to agencies to do things, it does it through statutes. The statutes will typically identify the high points, the big things, the important things that the agencies are being told to do, but will often allow agencies to fill in the details. And a lot of doctrines in administrative law are kind of have some grounding or relation to that kind of basic insight. But that if an agency wants to do something really big and really significant, so-called major question, the courts should be reluctant to believe that the agency has that authority if the agency can't identify a clear statement indicating that the agency has that authority. And for those that follow the court, this was very similar to the rationale the court gave in invalidating the Occupational Safety and Health Administration's rule requiring vaccination or testing for employees at firms with more than 100 employees. Very similar to the rationale the court hinted at when invalidating the Centers for Disease Control's eviction moratorium. In both those cases saying, hey, look, we have statutes. We know the statutes have traditionally been used. They haven't been used this way. Congress has given no indication it wanted to be used this way. What was particularly provocative, I think, about the way the court used the major questions doctrine was not that it relied upon with this kind of intuition that when Congress is delegating power, it identifies the big things, but it might not have identified the little things, but kind of the way it did it. So if you look back at a lot of the cases where the court in the past had used this idea, what the court usually does is it's a question about what power did Congress give the agency. Well, how do you answer that question? You look at the statute, and you look at what the statute says, and you look at its structure, and you look at maybe you look at its purpose. Some justices would look at its legislative history, some would not. You look perhaps how it interacts with other things on the books. And if when you're looking at all of that, what the agency is seeking to do seems a bit out of place or seems a bit aggressive given that broader interpretation, you maybe put your thumb on the scales a little bit to say, yeah, we're really not sure you have this power. So one case where the court did this that folks may be familiar with, about 20 years ago, a case called FDA versus Brandon Williamson. The Food and Drug Administration had asserted authority to regulate cigarettes as drugs and drug control drugs and drug devices, because cigarettes have nicotine and people use cigarettes for nicotine, and they're made for that purpose and sold and marketed for that purpose and so on. And if you were to apply the Food, Drug, and Cosmetic Act to cigarettes, you would probably have to ban them because drugs and devices have to be safe and effective when used as intended, and cigarettes are not safe when used as intended. And so the court there, and it was a close case, the court said, look, we understand the language of the definition of drug and the definition of device taken in isolation, combined with all these documents that came out of the tobacco company archives as a result of litigation about how they manipulate nicotine and nicotine delivery, and when they did, which they did a lot of. Why it might seem that this would apply to cigarettes, but we look back at the 70 years of legislation relating to tobacco, including subsidies to tobacco farmers and subsidies to cigarette companies to export their products, and special legislation about advertising and so on. And the idea that in the background the FDA had this power all along that it had never used just doesn't seem right. What was different about West Virginia and the FDA case, though, is if you read the FDA opinion, you get page after page after page of statutory interpretation and the structure of the statute and what would happen if you tried to apply the statute to cigarettes and all the other things Congress had done over the last 70 years related to cigarettes. And then it says, oh yeah, by the way, something this dramatic, right? Suddenly regulating an industry in the way it had never been regulated before and potentially banning the product, its primary products, is the sort of thing that Congress wouldn't have just kind of accidentally given to an agency. Congress does not hide elephants in mouse holes. Right? That something that big would have been conspicuous. What's different about West Virginia versus EPA, and that's going to have implications for a lot of other areas of law and a lot of other perhaps climate policies, is the court flipped the analysis. You read Chief Justice Roberts' opinion for the court, and it was a 6-3 decision. The conservatives in the majority, the liberals in dissent. He says, well, usually when we have a question like this, we read the statute and we read it in context, and we want to understand how it operates, but sometimes there are cases that are extraordinary, that implicate really big major questions, and in those cases we've used this major questions doctrine, which says that when an agency asserts a newfound or previously undiscovered authority to regulate broadly on a matter of economic and political significance, we demand a clear statement. And that inversion of the inquiry, I think, is significant in the way people will litigate these sorts of cases and the way courts do it. But it essentially, instead of using this major questions idea as kind of a tiebreaker at the end, it's using it as a way of loading the dice at the beginning. Because if up front you say, agency, you're doing something new and innovative and big, and we require a clear statement from Congress, the mere fact that you're litigating this is probably by itself evidence that there is not a clear statement, right? Nothing in the Clean Air Act says generation shifting. But so that was the rationale. The majority opinion did not engage in the sort of statutory interpretation we would normally expect. There's not a lot of discussion about the way the various parts of the Clean Air Act fit together. There's a little bit, but not very much. And as a consequence, the dissent from Justice Kagan kind of really hammers this point, because just the dissent argues that best system of emission reduction seems pretty broad. If you're talking about a system of emission reduction, nothing in the statute explicitly says that system has to be at the source as opposed to elsewhere in the grid or elsewhere within the utility's control. And why isn't generation shifting a system of emission reduction? Because it's someone that's done Clean Air Act work for, 30 years now, there are lots of responses, there are lots of arguments, there are lots of textual arguments that one could make to respond to that, and they're just not there in the majority opinion, which is interesting. But so the court said EPA cannot do this because generation shifting, adopting an emissions control measure with the purpose and effect of dramatically altering the energy mix within electricity generation is a major question that Congress had not clearly delegated to the EPA. EPA cannot do it. The court did, though, then say all it was saying, in effect, was that generation shifting could not be the basis for best system of emission reduction, and therefore the DC Circuit opinion was wrong. There's this very cryptic paragraph near the end of the opinion that says, we're really saying nothing else about the statute. And it's unclear if that paragraph is, we heard the utilities were on the side of EPA and we don't want to totally screw things up for them, or the Clean Air Act's a really big, long, and complicated statute, and we're afraid if we say much more about it, we might get something wrong and make a mistake, and we don't want to do that. It's unclear precisely what the point of that paragraph is, but the effect of that paragraph is to basically say generation shifting cannot be mandated. New rule is adopted that uses some other basis for determining the best system of emission reduction. Generation shifting could be used to comply with that rule. It just couldn't be used to set the emission reduction target in the first place. And that's significant because that means if we do get another rule, utilities will have flexibility on the compliance side, which will matter a lot for the costs of any rule, because if you can generation shift, the costs are a lot lower of reducing greenhouse gas emissions from power plants. If you can't generation shift, you either will get no emission reductions or the cost will be high.
Well, you sort of answered this, but just to make it really clear for everybody, I mean, what happens now, and is there any real prevention of the EPA from regulating greenhouse gases as a result of this decision?
So, I kind of said this already, but so the first thing the EPA had done after greenhouse gases were declared pollutants under the Clean Air Act was regulate emissions from new motor vehicles under Section 202, not affected by this decision at all. So we have a national standard that's been tightened, and there's also the Clean Air Act allows California to have a separate standard, and states are allowed to choose, do they want the California standard or the background federal standard. The waiver as applied to greenhouse gases for California is also being litigated, but I would think California will likely win that litigation. So that isn't changed. Greenhouse gases are pollutants for purposes of some stationary source regulation already. Basically, stationary sources that are considered major sources under other provisions of the Clean Air Act have to control greenhouse gas emissions. As well, greenhouse gas emissions just aren't a trigger for those stationary sources. For Section 111, EPA can still regulate greenhouse gas emissions from power plants. Nothing in the litigation questioned EPA's threshold determination of endangerment or its authority to use Section 111 for greenhouse gases. The Biden administration is in the process of developing a new rule under Section 111 that we expect a draft or a proposed rule, which is basically the proposal that is subject to notice and comment in the rulemaking process, to be issued in 2023, early in 2023, and with a final rule by 2024. So a rule should be able to be finalized during the Biden administration's first term, although it will get litigated. In terms of the options they have, the Section 111 says EPA has to determine what the best system of emission reduction, considering cost, also has to consider other environmental impacts and effects on like the reliability of the grid in the context of utilities. When the Obama administration did the rule and when the Trump administration did their rule, they both concluded that declaring carbon capture and sequestration from existing coal-fired power plants, right? So we're talking about plants that are in operation that you have to retrofit, not new plants that you could design from scratch, would not satisfy the considering cost problem. The Biden administration might argue that the cost of carbon capture and sequestration has come down enough that they can use that as the basis for the best system of emission reduction, which would then give you a much lower target. A safer strategy they might use is to base the best system on emission reduction on co-firing. So basically say, okay, we're going to do something inside the fence line, but what we're going to basically say is that there are ways to combine fuel sources within the power plant so that you're using essentially a mix of coal and other things, in particular natural gas, so that you reduce the overall greenhouse gas emissions from combustion. And there are folks that believe that the costs of co-firing are low enough that would work. And then because of the narrowness of the Supreme Court's opinion, if that were the basis of the rule, utilities could then still decide to generation shift as a way of meeting the standard that was based on co-firing. But we won't know until they issue their proposal what they're going to do. There may be other technologies they think they can use as the basis for that. So that's one thing they're going to do. The other thing that they're going to do, which is riskier, but I think they'll do it because EPA is going to use the tools it has, is to look at other regulations under the Clean Air Act, which are targeted at traditional pollutants, like say particulates, often happen to be produced in high quantities from coal, and tighten those regulations, recognizing that if you tighten those regulations, you will also get greenhouse gas emission reduction benefits. So, for example, if the EPA were to lower or tighten the national ambient air quality standard for fine particulates, a co-benefit of that would be greenhouse gas emission reductions, and arguably significant. And the mercury rules, other sorts of things you can do that. The legal risk there is whether or not coal companies and red states that challenge that can convince courts that there is some kind of subterfuge going on. So in the West Virginia case, very much so in the oral argument for the case, and in some of the COVID litigation, it was very clear that some of the justices were thinking about these sorts of major question ideas in terms of, if Congress gave you a wrench, you have a wrench, and you do things that you use a wrench for. I don't know how some of you do home repairs, but if I'm like up in my daughter's room, which is on the 3rd floor, and my toolbox is in the basement, and all I have with me is the wrench, and I need to nail something in, you turn the wrench kind of by its side and you aim it carefully. You might be able to drive a nail in if you're not going into something too hard, and you can kind of use the wrench as a hammer. There's reason to think that the current court is suspicious of that almost views that sort of thing as pretextual. So, for example, in the OSHA COVID litigation, the court was clearly bothered by lots of statements by the administration that the point of the rule was to increase the vaccination rate in the country. Good thing to do. The Occupational Safety and Health Administration does not have the power to increase vaccinations. It has the power to make workplaces safe. And at oral argument in the opinion, you see hints of, if Congress gives you a given power to solve a certain type of problem, and you want to address a different problem, you're supposed to go back to Congress and ask for the power to address the different problem. That the purpose of the power you've been given constrains how you can use that power. And so my own view is what the Biden administration would have to be really careful about is, say, tightening the standards for particulates, is being able to justify that purely in terms of particulate reductions. And I'm not up enough on what the current science is on what the level of, but assuming they can make the case that, we consider a tighter national ambient air quality standard, it's okay to get the co-benefits from greenhouse gas emission reductions, but it would be legally risky to tighten a regulation of fine particulates for the purpose of getting greenhouse gas emissions. Whether or not that's the way courts should review what agencies do or not is an interesting question. It's a relatively new thing in administrative law to begin to focus on those sorts of things. Because agencies often do things for lots of reasons, including political reasons. And we usually just care about whether the justification they give on its face is adequate. But I think West Virginia, in some of these cases, signal that the court is a little worried about, in an age of legislative inaction, agencies repurposing. So that's an area where I think the Biden administration has risks. This case doesn't say anything about state authority. So states that want to be more aggressive and are continuing to be aggressive aren't affected. But the EPA will have to be careful in terms of how it thinks about using the tools it has to address greenhouse gas emissions.
Well, I know I'm going to be looking at my toolbox later, and now I'll be thinking about climate policies and what we can do, and I'll be right back.
And by the way, don't use a wrench to hit nails. That was a hypothetical. It is not home improvement advice.
Well, thank you for all of that, and I'd love to get your thoughts on how this will affect other climate policies. Is this decision going to get in the way of any other efforts by federal agencies to address climate change or other efforts by the EPA?
It might. I mean, the case that everyone is thinking about as being the next kind of major questions case related to climate policy is the Securities and Exchange Commission is considering adopting a rule that will dramatically increase the obligations of publicly traded companies to report on climate change related matters. And there's a range of things And we've done the Burke Center's done a webinar on this, and we'll be doing another one this year. And the idea there is that insofar as the SEC is, or we don't have a final rule yet, so it's somewhat hypothetical, but the assumption is that the SEC is going to require reporting for things that arguably go beyond the traditional sorts of financial risks that companies are required to disclose to shareholders, such as emissions that relate to the life cycle of their products that they themselves might not be responsible for, and so are not a function of the risk that climate change poses to the company's operations, and aren't necessarily even a risk that climate change policy poses to the company's operations. And if that's what the SEC does, we will see a major questions type lawsuit filed right away saying, SEC, you do securities, you don't do climate. If Congress wants you to do climate, they will tell you to do climate. They haven't. That's a major question. You can't do it. And depending on what the SEC rule looks like, that could be a serious challenge. I mean, I'm assuming that attorneys at the Securities and Exchange Commission have spent all summer thinking about this. There's some other things at FERC that raise similar sorts of questions, and the kind of the for agencies other than the EPA, if they are trying to use, and then the toolbox analogy I think fits here too, if they're trying to use old statutory authority that was enacted before we were really focused on climate change, and trying to leverage it to reach greenhouse gases, then just from a litigation risk standpoint, I would say the agency is treading into dangerous territory and needs to be careful. And that will both mean that those sorts of things will be more vulnerable. It'll also mean that they'll take more time, right? Because as I tell my administrative law students, when agencies are thinking about doing things, the more you know that you're going to get sued and the sorts of things you're going to get sued over, if you're doing your job, the more time you're going to spend dotting your I's, crossing your T's to try and protect yourself. And so, that makes it harder for agencies to operate quickly in this space.
Yeah, and to that effect, excuse me, the most recent climate, Congress authority is the Inflation Reduction Act. And do you think this is going to have any impact on that or other legislative efforts?
Yeah, it doesn't. I mean, what's really for CPA, whether you like the decision or don't like the decision, is all about what power did Congress give the agency. It's not about what Congress can give an agency, right? So there's nothing in the decision. There's not even really anything in Justice Gorsuch's concurrence, which was where we might have thought we would see this, suggesting that there are outer limits on what Congress can give to agencies in the first place under something called the non-delegation doctrine. So as long as Congress is clear and enacting new legislation, there's nothing in this decision that would get in the way. Now, that doesn't mean there won't be litigation, but there's nothing in this decision. In the Inflation Reduction Act, the other thing is that Congress there is using fiscal tools, spending, taxes, tax reductions, selective taxation, and the like. And as a general matter, those are much less vulnerable to legal challenge for a whole bunch of reasons. The easiest one to understand is that when the government regulates you can sue over that. The government's telling you what to do. If the government increases your costs directly, you can sue over that. If the government does something nice to somebody else, gives them a tax credit, gives them a subsidy, you don't have standing to sue over that. So you might not like it. You might think it's illegal. You might think it's unconstitutional. Fine. But that's not something that's going to get into court. So the Inflation Reduction Act itself, very little legal litigation risk there. The litigation risk that's kind of ongoing, and I saw it before we started. I saw someone email something that suggested the permitting reform bill might be dead. I don't know. So when we're done, we can look. But there will be some of the projects that the IRA is funding and facilitating will face the same sort of legal environment they've always faced, because the Inflation Reduction Act itself didn't do much to streamline those processes. Congress might try and streamline those processes. There's a risk there because it's hard to streamline the processes just for the things you like and not for the things you don't like. Not that you can't do it, but it's just harder. So those sorts of things will still be ongoing, but there won't be, I don't think, real legal risk to IRA stuff directly.
Yeah, very, very different type of statute there. So they are considering, the Supreme Court is considering taking another climate case, Suncor versus City of Boulder.
Yes.
Can you tell us about the issues in that case?
About that, and then we should get questions from folks. So there's this case that the Supreme Court has on its conference. The Supreme Court has the last week of September, or the last week before the first Monday in October, which is usually the last week in September, but sometimes not. Next Monday is the first Monday in October. That's the opening of the Supreme Court term. The week before that, the Supreme Court has what's called the long conference, where they consider petitions for certiorari, so petitions asking the Supreme Court to take cases that have kind of accumulated over the summer. And one of the cases the Supreme Court's being asked to take is a case called Suncor versus Boulder. And this is one of a number of cases that have been filed mostly by city governments. There have been a couple by states, and a couple by counties, I guess, but mostly by local governments against fossil fuel companies, arguing that the way that fossil fuel companies marketed and sold and distributed and produced fossil fuels resulted in consequences to these jurisdictions that they now have to pay for. Changes in precipitation events resulting in stresses to stormwater systems or requiring investments in infrastructure and the like that would not have had to have been made, and seeking to hold fossil fuel companies liable for this. And all these cases the bulk of these cases have been filed in state courts under state law. The fossil fuel companies have been trying to get these cases into federal court, both because they think it's easier to slow them down that way, because they want to avoid any kind of these cases getting to trial, and because they think it's more easy to claim the cases are preempted. And so this case, the Suncor and the other fossil fuel defendants are arguing that these cases should be subject to complete preemption under federal law and therefore should be removed to federal court and kind of wiped away. I don't think the court's going to take this case, but if it takes it, it's a big deal because as a political matter, part of the leverage to get some sort of climate legislation that's regulatory or something like a carbon tax or anything like that would be some sort of deal, similar to what we saw with tobacco, where you say to the companies, you want all this litigation to go away? Okay. Support legislation that constrains your emissions and your production, and the litigation will go away. And companies will often take that kind of deal because the legislation is more certain than the litigation, because who knows what a jury's going to do, right? And so they're trying very hard to figure out how to make these cases go away. And if the court were to take the case, that would certainly suggest that at least 4 justices, because that's how many it takes to accept a case, are skeptical of this litigation, skeptical that courts, and in particular state courts, are a good place to resolve climate policy, and therefore it should be preempted. And folks that are curious, I actually have a paper out that says, yes, in some respects, if you were going to decide where is the best place to make climate policy, state courts would not be at the top of your list. But under our legal system, state law is only preempted if Congress preempts it. And Congress hasn't. And especially in the environmental law context, our history is a history of where states, both through their legal systems, through the court systems, and through legislation, have been the primary drivers and innovators of environmental policy, through nuisance law as well as through state regulation. And that authority has only ever been preempted when Congress has said we should preempt it. And so if people believe it should be preempted, they shouldn't be taking those arguments to the Supreme Court. They should be taking those arguments to Congress and trying to strike a deal for some sort of global climate policy or national climate policy to replace them. But who knows if the court will find that convincing. But
And we'll know soon, right?
well, so we could know tomorrow, we could know Friday, we could know Monday. If the court is going to reject the petition, I would say there's a good chance we'll know Monday, because they usually release denials of certiorari on Monday. The recent practice of the court is to not accept petitions for certiorari right away. They usually do what's called a relist, where they agree to consider it at a second conference. And basically the idea is that if there's a case we think we might want to take, let's look at it extra closely and make sure it's actually worth the Supreme Court's time. And that's kind of and so if there will be a long order list that will be released sometime between now and Monday. And if this case is on that list, it's probably a denial. If it's not on that list, that means at least some of the justices are very interested in possibly taking the case, and that would be an ominous sign for these cases.
Very much. And if anyone has questions,
Questions?
I'm happy to take questions now.
Questions, comments, concerns?
This may be obvious from what you said, but I know this was a climate change lecture, but you could have had another lecture just on the major question doctrine, which may seem actually more important than what they did with.
I mean, I guess it depends what your primary focus is, but yeah, I mean, it's a big deal. I mean, and I've written some stuff, and I think when Tom Merrill was here, I guess a week or so ago, in the lecture he gave on the Chevron Doctrine, and that's the video that's on the Burke Center website for those that are interested, has a similar view that there is an intuition in what the court kind of underlying that makes some sense. The whole, the idea that when a principal delegates authority to an agent, we expect the big things to be clear and filling the deals is okay. But you kind of adopt that as an overall principle. You don't have a light switch where you say major questions, whatever they are, because the court's not very clear on that. I mean, economic and political significance, an unheralded power, and it has to be something that Congress failed to do, which is really hard to evaluate. Does it mean that they have to have a vote? Well, what if the bill was killed in committee? What if somebody was going to introduce a bill, but they know how to count votes? I mean, who knows, right? And so that idea is important in an era of legislative dysfunction. I'm one of those that thinks Congress does more than we think it does, but doesn't do nearly as much as it should. And one of the things it really doesn't do is keep legislation up to date. Right? We saw this with COVID. We see this across the environmental statutes, not just with climate change, right? So Clean Water Act turns 50 this year, primarily targeted at point sources. We've done the vast bulk of what we can do with point sources. With water treatment plants, and maybe there's some more we can do, but non-point source pollution. But the statutes, whether or not in 1972 Congress knew better, we know today that if you want legislation to deal with water, right? So we can tell the same story across laws, or anything that relates to tech. Our banking laws were not written for doing your banking on your phone, right? They were written for those old days where you have to go in and sign triplicates, and you have a carbon paper, not carbon emissions. So it's significant, and the message seems to be, Congress, you're supposed to be doing your job because you're the source of the power the agencies exercise. And the court seems to be frustrated with I don't think it's a Biden administration thing or even an Obama administration thing, because the Trump administration did a lot of this, and the Bush administration did a decent amount of Congress isn't going to give us what we want, so we're going to do our own thing. And that's in fact part of why we don't have climate legislation. So the Bush administration wanted a bill to dramatically reduce pollution from power plants, and they wanted a 3 pollutant bill, and Congress wanted a 4 pollutant bill, the 4th being greenhouse gases. And the Bush administration said, yeah, we don't want a 4 pollutant bill, so we're going to just try and do everything we want administratively. and they tried, and most of it got thrown out in court. But that's, it's a bigger problem, right? Congress is not keeping legislation up to date. It's not, it's spending its time, members of Congress spend their time trying to get, viral Twitter videos and get on cable news and conducting oversight investigations, not legislating. And the major questions doctrine definitely makes that have more consequences. I will confess, I am, as a kind of matter of constitutional structure, I'm sympathetic. But it definitely makes it challenging to deal with federal problems because Congress isn't yet responding appropriately. Other questions?
What implication does West Virginia have, if any, on the two social cost of carbon cases? One by Missouri that was dismissed, and the one by Louisiana.
I don't. So there are these cases. So there are a whole bunch of contexts in which federal agencies kind of think about the costs and benefits of what they do. A lot of it under executive order. Some of it pursuant to things like the National Environmental Policy Act when they do environmental impact statements. And the Biden administration, like the Obama administration, wanted to identify a cost of carbon. What are all the consequences of climate change, and how do we try and account for that when we do things like cost-benefit analyses and the like? It was a bigger number than the Trump administration had wanted to use, and so two lawsuits were filed by red state attorneys general challenging the Biden administration's social cost of carbon, trying to argue that there's no authority to do this, and that's a major question. I don't think this case has much of an implication. West Virginia has much of an implication for those cases because those cases have been foundering because there's no basis for the litigation in the first place. So the social cost of carbon is not a final rule. It's not a final agency action. It is basically a White House recommendation of this is the number we think you should use when you do something substantive. And so if there's a problem with the number that the Biden administration is using, and I don't know, I know some people think it's too low, some people think it's too high. The only way you would challenge that is in the context of a final agency action of consequence, like a regulation, or perhaps even an environmental impact statement that incorporated that social cost of carbon into the analysis. And then if you could convince a court that relying upon that number was arbitrary and capricious, you might have some success there. But the idea that the social cost of carbon is any more a major question than a quality adjusted life year, which is used for cost benefit analyses, or benchmark numbers for willingness to pay and willingness to accept for other life-saving interventions, or any of the other sorts of things which are very significant and weighty that we apply numbers to when we do cost benefit analyses and try to have some sort of consistency across agencies. The idea that any sort of executive branch recommendation of what that number is or what that analysis should look like is a major question that can be challenged on that basis, I just don't think works. And it doesn't work, first and foremost, there are many reasons, and I did some blog posts on this, but the biggest reason being is that it's not the sort of thing you can sue over because it's not by itself an agency action. It's not something that has a legal consequence on a private citizen or a private industry that they then can sue over. So Louisiana's case was they won in the trial court, and then the Fifth Circuit reversed them and stayed them, but effectively stayed the injunction. So, which was a way of saying, this was not the injunction.
That is that social cost of carbon rule, or whatever you want
not
to
a
call
rule.
it. 1390, the executive ordered it.
Executive orders aren't final agency actions either.
No. Here's the rest of the question, because it goes to what you said. It said that every agency and every action they take, they must incorporate the social cost of carbon.
It doesn't really say that.
I don't know if they've done,
Yes.
but if they did, that's the kind of event you think it would trigger
Maybe.
proper litigation?
mean, maybe, but unlikely. I'd want to double check that exactly. But almost every executive order always says that tells agencies what to do, somewhere in it. Insofar as it's consistent with law, agencies should, and then all the things. And there's always something at the end that says nothing in here changes any legal obligations agencies have, because executive orders can't change the legal obligations agencies have. So executive orders are almost always written explicitly to acknowledge that limitation on the president's authority to superintend agency behavior in this way. And even if they didn't, because presidents don't have the authority to simply make law on their own, an executive order couldn't have that effect anyway. So even if the executive order said, you must use $1 billion as the per ton of carbon, right? It didn't even say, well, look at this working group. Just gave a number. Until an agency actually used that number as the basis for a regulation, there still would be no basis to challenge it. And further underlining that, the president's not an agency for purposes of the Administrative Procedure Act. So I mean, there's just not even how there's just no hook. And so what'll have to happen is, so let's say the social cost of carbon is referenced in a regulation that limits offshore oil drilling. And let's say Louisiana doesn't like that because Louisiana gets lots of tax revenue from oil drilling and the economic activity associated. They could challenge that. And one of the arguments they could make is this number, insofar as it was the basis for the decision, was arbitrary and capricious. They would still have a problem that they'd have to be able to argue that that number is the reason why the agency took the action it did. And in most contexts, that's going to be really hard as well, because typically the cost-benefit analysis that an agency does under most statutes is informational, is not decision-forcing. It's understood that most cost-benefit analyses that agencies do are done as a result of executive order, not as a result of statutes. And they're mostly done with the idea that this enhances accountability, because agencies are telling us we've looked at the pros and cons, and here's how we try and quantify it, and here's why we think on net this is a good thing to do. But they ultimately typically ground their decision in the statutory authority for controlling oil drilling or whatever it is. And so I think even there you'd have a hard time getting at the social cost of carbon. And so I view that litigation as really, it's symbolism, right? Red state attorneys general want to challenge the mean Biden administration that's beating up on fossil fuels and destroying these jobs and yada yada yada. And so they file cases that will attract attention and show that they are fighting that fight. And when there's a Republican president, blue state attorneys general do the same thing, just on a different set of issues. I don't really view it as the fulcrum of kind of serious policy litigation, whereas West Virginia versus EPA clearly was litigation over the SEC climate disclosure rule. When we get that rule, will be. I think those other sorts of things are where you really see serious challenges to efforts to. And so, if the EPA were to try to adopt a Section 115 rule, if it happens, it will be a big deal. This is a part of an obscure version of the Clean Air Act that allows the EPA to adopt regulations to enforce international commitments or to do things reciprocal with other nations. And it's kind of this sparse, somewhat ambiguous language, which you can see pouring a lot of content into. And you're there, okay, that would be big litigation. Social cost of carbon litigation, I don't think those cases are going to go anywhere, and I think there are reasons for that. Yeah.
So this is from Ina Martin, who's online.
Awesome.
I have a question. I'd be interested in knowing if and how you recommend ordinary people can get involved in the legislative, political aspects of climate change.
I mean, certainly, I think a couple things are important. I mean, if you want policy change, some of the most important things to do is to deal with legislators, whether that's at the state level or at the federal level. I say state and federal and not local because in Ohio, like in most states, and Randy can actually probably give you more chapter and verse than I can, a lot of the relevant energy, not all, certainly not land use related things, but a lot of energy related policy questions are kind of kept in the hands of the state government. And so you just don't have as many levers in local government other than land use things. The other thing that I would suggest, and some of you know this is one of my hobby horses, try and think of ways to help legislators not see these issues in red and blue terms. Because the way our political process operates now is that once an issue is viewed in those terms, it becomes a binary thing, and one side has to have a significant majority over the other for anything to happen. And that usually means nothing happens. And so I think that beyond making clear if climate's important to you, that to your elected representatives, that it's letting them know that treating this as yet another issue in our tribal battles amongst one another is not helpful to coming up with ways of addressing this problem. Maybe I would say that I hope to think this is also one of those issues where progress looks impossible until it doesn't, and that there could be Nixon goes to China kind of moment where things suddenly look very different. But that's what I would encourage. Being involved, being educated, knowing what your legislators think about these issues. Try to help them think about it in other than the traditional partisan terms. Yeah.
Follow-up question: are there nonpartisan climate voices in Ohio State Legislature should engage?
Randy would know this better than I would.
Is she asking about legislators or groups that are involved? Or?
She said nonpartisan climate voices, so I guess like advocacy groups that...
there are advocacy groups that work to try to work in a nonpartisan way. Some of them are kind of focused on specific issues. So there are a bunch of issues at the federal level, at least, that focus on things like carbon taxation that work very hard to not be partisan, and point out that certainly a lot of kind of conservative or Republican-leaning economists think that carbon taxation is a very effective thing to do, and there does seem to be some support for things like some bipartisan support, not enough to get something passed, but some bipartisan support for things like carbon border adjustments. So basically a way of oversimplifying, but altering tariffs so that you're accounting for carbon content of products when they're imported. At the state level, I know the federal level more than the state level. Randy might have ideas in terms of the state level.
Yeah, there are different types of groups. Some of them work at federal level and at the state level, but they're, for example, Citizens Climate Lobby is, to Jonathan's point, there's some specific topic areas they're looking at. They're looking at cost of carbon. So that's one of that's their way of pushing climate policy, and they do work very hard to be nonpartisan. There's an Ohio chapter that works really hard. There's even local chapters. So that's one way to get involved. I would also say there's, just to your point earlier, we need to make this not a partisan issue, right? This is just about our economic and health future. And so when we look at this from a political or politicized angle, we're doing everyone a disservice. And so really looking at this from different angles is really important, and having those conversations about the economics of this, about how this impacts health, about how this is going to look at things on a long-term basis, going to make everything more difficult. And there are also groups that are from the conservative lens looking at this. The Ohio Conservative Energy Forum is an excellent group working on this at the state level with legislators here. There are other organizations, and going back to the local level a little bit, there's an organization called Power Clean Future Ohio. They actually spoke last night at one of our events on community trace aggregation, and they're working really hard to help local leaders, and they have leaders across a nonpartisan kind of space looking at this and what it's going to cost them to comply with the different impacts that are affecting their citizens at the local level. So again, looking at this from a nonpartisan perspective is really, really critical, and I hope that our legislators can start to look at this as just, how are we facing this challenge that's coming up, whether or not you agree with where it's coming from, we are all seeing the impacts of this, and so it's really important to look at that from that perspective. And in that lens, contacting your lawmakers at the state and the local level is really important.
Apropos to which you just stated, Tori McMillan is the local contact for Citizens Climate Lobby. And her phone number, Tori McMillan, is 603-401-3194. I feel confident and comfortable in giving her number because I know she would like to see generate greater support. And it just so happens that on October the 27th at 7 o'clock, I believe it's the Shaker Heights Public Library. I'm not certain if the venue has been determined, but I actually am going to be making a presentation there on how to effectively lobby elected officials. I served in the General Assembly for 5 years and a 22-year career as an elected official, and so we're going to be talking about that topic on October 27th. Again, Citizens Climate Lobby, contact Tori McMillan.
There was another question back there. Yeah.
My question was update legislation. I don't know. Do you, in this political climate, do you see that changing, or do you see that continuing, or do you believe there's a solution to that problem? Just because for how long I've been looking at politics, it feels kind of just always back and forth without any actual steps forward.
So, with a co-author, I've done some work looking at how Congress could try and change the incentives that Congress operates under so that it would revisit things more often. There are examples of it, of where it works, but there aren't very many. Usually where it works is where enough interests are on the line that you have to, because things expire. But members of Congress have realized that, and so they don't let things expire, don't let expirations have consequences. There are, I think the way I would characterize the dynamic, and it relates to the last question, is that there are things that, Congress does more than we think it does. When something is really salient and there's broad consensus on the need to do something, Congress tends to act. The best example of that in recent years was probably, some of the COVID legislation was an example of that, but also the response to scandals in the VA health system are an example of that, where Congress moved very quickly. The challenge is that once something is viewed kind of through tribal lenses, red team, blue team lenses, then the substance becomes less important than kind of which team wins. And so, for example, it's possible that permitting reform legislation has died. Now maybe it'll come back. Some folks supported it because they thought it was necessary for clean energy infrastructure to be built cost effectively and quickly. Some people supported it because it would allow other things to get built too. Some people opposed it because of the latter part. Some people opposed it because they're upset with Senator Manchin because he voted for the IRA and and so it was as payback. And I think that latter dynamic is the sort of example of the sort of dynamic that we have to be wary of and try and work against. I do think that climate is an issue that where you could see that sort of dynamic where it doesn't fall into that. I do think that it probably will require leadership from the right, because I think politically you need a kind of Nixon goes to China sort of dynamic, right? Why could Nixon open relations with communist China? For those of you that aren't old enough to remember this, or your high school history class ended in the 1940s, and so you didn't get to this part. Nixon's early political career was as a very staunch anti-communist, just short of McCarthy. And so when he wanted to open up relations with the People's Republic of China, he couldn't be accused of being soft on communists because he was Nixon. And everyone knew Nixon was really anti-communist. And so he had political space to do that. And and especially when things on issues that are very partisan, political leaders tend to have space to do things that play against type, right? So to do things that you wouldn't expect from their side. And so my own view, and I know a lot of folks don't agree with this, my own view is that it will take some amount of conservative leadership to kind of inoculate the issue from attacks, tribal attacks. There were early reports that Ivanka was trying to convince her father to do that in the last administration. That clearly did not happen. But I don't think that necessarily means you need a Republican president, right? It could be simply enough that enough Republican legislators, maybe from Florida, say, we're kind of concerned about this. But I do think that it will require that sort of thing, or supermajorities, right? I mean, if you have a supermajority in Congress where you can just do what you want, then that solves that problem. But I do think, again, Congress does more than we sometimes give it credit for. It just doesn't do it on the things that we tend to be most excited about. And unfortunately, at the current moment, climate is in that. Should we wrap it up? Yeah. We have a reception on the other side of this wall, so walk around so we can continue the conversation at the reception. So please join us for that. Certainly check out the other Climate Action Week events that are being sponsored and run in various parts of the university throughout the week. And thank you for coming. And certainly a plug for Burke Center. We have a bunch of climate-related programs on the website, including webinars on a bunch of subjects related to some of the things I talked about today that are free to view, and certainly encourage you to do that as well. So thanks for coming.